In pejorative usage, a patent troll is a person or company that attempts to enforce patent rights against accused infringers far beyond the patent's actual value or contribution to the prior art. Patent trolls often do not manufacture products or supply services based upon the patents in question. However, some entities which do not practice their asserted patent may not be considered patent trolls when they license their patented technologies on reasonable terms in advance. Other related terms include patent holding company, patent assertion entity, and non-practicing entity, which may or may not be considered a patent troll, depending on the position they are taking and the perception of that position by the public. A variation of the problem is when companies do make some degree of attempt to develop products but, when the product fails, conclude that they can instead be more successful at litigating a portion of the profits from those that become more successful at development. Patent trolling has been less of a problem in Europe than in the US, because Europe has a loser-pays-costs regime. In contrast, the US generally used the so-called American rule, providing that each party is responsible for paying its own attorney's fees, until U.S. Supreme Court decided Octane Fitness, LLC v. Icon Health and Fitness, Inc. on April 29, 2014. Etymology and Definition. The 1994 educational video, The Patents video, also used the term, depicting a green troll guarding a bridge and demanding fees. The origin of the term patent troll has also been variously attributed to Anne Gundelfinger, or Peter Dedekind, both counsel for Intel. During the late 1990s, patent troll is currently a controversial term, susceptible to numerous definitions, none of which are considered satisfactory from the perspective of understanding how patent trolls should be treated in law. Definitions include a party that does one or more of the following: purchases a patent, often from a bankrupt firm, and then sues another company by claiming that one of its products infringes on the purchase patent, enforces patents against purported infringers without itself intending to manufacture the patented product or supply the patented service, enforces patents but has no manufacturing or research base, focuses its efforts solely on enforcing patent rights, or asserts patent infringement claims against non-copiers or against a large industry that is composed of non-copiers. The term patent pirate has been used to describe both patent trolling and acts of patent infringement. Related expressions are non-practicing entity, patent assertion entity, non-manufacturing patentee, patent shark, patent marketer, patent assertion company, and patent dealer. Confusion over use of the term patent troll is clear in research and media reporting. In 2014, PricewaterhouseCoopers published research into patent litigation, including a study of non-practicing entities including individual inventors and non-profit organizations such as universities. In quoting that research, media outlets such as The Washington Post labeled all non-practicing entities as patent trolls. Legal and regulatory history. According to RPX Corporation, a firm that helps reduce company patent litigation risk by offering licenses to patents it owns in exchange for an agreement not to sue. Patent trolls in 2012 filed more than 2,900 infringement lawsuits nationwide. In addressing the America Invents Act passed by Congress in September 2011 reforming U.S. patent law, U.S. President Barack Obama said in February 2013 that U.S. efforts at patent reform only went about halfway to where we need to go. The next indicated step was to pull together stakeholders and find consensus on smarter patent laws. On June 4, 2013, President Obama referenced patent trolls and directed the United States Patent and Trademark Office to take 5 new actions to help stem the surge in patent infringement lawsuits tying up the court system, saying, "They don't actually produce anything themselves. They're just trying to essentially leverage and hijack somebody else's idea and see if they can extort some money out of them. Mr. Obama ordered the USPTO to require companies to be more specific about exactly what their patent covers and how it is being infringed. The administration further stated the USPTO will tighten scrutiny of patent claims that appear overly broad, and will aim to curb patent infringement lawsuits against consumers and small business owners using off-the-shelf technology. The president asked Congress to enact legislation to more aggressively curb abusive lawsuits. David Kravitz said History eBooks will remember the 44th president for setting off a chain of reforms that made predatory patent lawsuits a virtual memory. In the U.S. Congress, Senator Orrin Hatch sponsored legislation in 2013 intended to reduce the incidence of patent trolling. The bill, called the Patent Litigation Integrity Act, would help judges make patent trolls pay for the cost of the lawsuits, especially if the trolls lost the lawsuits. In February 2014, Apple filed 2 friend-of-the-court briefs for cases pending in the U.S. Supreme Court, claiming to be the #1 target for patent trolls, having faced nearly 100 lawsuits in the preceding 3 years. In November 2014, the U.S. Federal Trade Commission settled its first consumer protection lawsuit against a company for using deceptive sales claims and phony legal threats. The FTC found that defendant MPHJ had sent letters to more than 16,000 small to mid-size businesses threatening patent infringement lawsuits if the companies did not comply with its demand for licensing fees of $1,000 to $1,200 per employee, but never making preparations for such lawsuits. The 2014 settlement provided for a $16,000 fine per letter that MPHJ or its attorneys would send. State responses in the United States. In May 2013, Vermont's Consumer Protection Act took effect. The Vermont law prohibits bad faith infringement threats, with bad faith indicated by lack of specificity of the alleged infringement, settlement demands or damage claims that include excessive licensing fees, and unreasonably short deadlines for payment of demanded monies. Vermont's statute gives recipients of threat letters the right to countersue in state court, thus making it a less lucrative business model to send out large numbers of threat letters. As of August 2013, the Vermont legislation had not been tested in court as to violation of federal preemption. In August 2013, Nebraska's Attorney General sent warnings to a patent trolls law firm, asserting that to send frivolous licensing demands to Nebraska businesses may constitute unfair and deceptive business practices and violate Nebraska's unfair competition law. In 2013, Minnesota's Attorney General obtained a settlement prohibiting MPHJ Technology Investments LLC from continuing its licensing campaign. Minnesota is said to be the first state to obtain such a settlement. In February 2014, the Wisconsin State Assembly passed legislation that would make patent trolling Wisconsin companies illegal. The legislation is pending in the state Senate. In the 2014 legislative session, Idaho Lieutenant Governor Brad Little sponsored Senate Bill 1354, or the Patent Troll Bill, which protected companies from bad faith assertions of patent infringement, in which a patent holder frequently harasses businesses for purportedly infringing on a patent in order to collect an extortionate licensing fee. Causes. The cost of defending against a patent infringement suit, as of 2004, is typically $1 million or more before trial, and $2.5 million for a complete defense, even if successful. Because the costs and risks are high, defendants may settle even non-meritorious suits they consider frivolous for several $100,000. The uncertainty and unpredictability of the outcome of jury trials in the United States also encourages settlement. It has also been suggested that distortions in the patent market, such as those caused by the examination backlog, promote patent trolling. If the Patent Office accepts claims that have been invented, published or even patented before, ignoring material prior art, then even existing technologies in use are subject to patent trolling. Re-examination to invalidate the patent based on prior art can be requested, but requests are typically made only after a lawsuit is filed or threatened, and often in conjunction with an infringement lawsuit. Only the patent holder will participate in this process, and the party requesting the re-examination has no right of appeal and is stopped from using the same evidence in any subsequent civil action. This risk keeps the popularity of re-examination low despite its lower cost. Furthermore, the most common outcome is not the validation or invalidation of the patent, but narrowing the scope of the claims. There is also no obligation to defend an unused patent immediately. Thus, manufacturing companies may produce the patented product for years until the patent troll sues them. For example, the JPEG format, intended to be free of license fees, was subject to 2 patent attacks. One by fraudulent networks during 2002 to 2006 and another by Global Patent Holdings during 2007 to 2009. Both patents were eventually invalidated based on prior art, but before this, Fraudulent collected more than $100 million in license fees from 30 companies and sued 31 other companies. Effects. In 2011, United States business entities incurred $29 billion in direct costs because of patent trolls. Lawsuits brought by patent assertion companies made up 61% of all patent cases in 2012, according to the Santa Clara University School of Law. From 2009 through mid-2013, Apple Inc. was the defendant in 171 lawsuits brought by non-practicing entities, followed by Hewlett-Packard, Samsung, AT&T, and Dell. Patent troll instigated litigation, once mostly confined to large companies in patent-dependent industries such as pharmaceuticals, came to involve companies of all sizes in a wide variety of industries. In 2005, patent trolls sued 800 small firms, the number growing to nearly 2,900 such firms in 2011. The median defendant's annual revenue was $10.3 million. A July 2014 PricewaterhouseCoopers study concluded that non-practicing entities accounted for 67% of all patent lawsuits filed, up from 28% 5 years earlier, and though the median monetary award size has shrunk over time, the median number of awards to NPEs was 3 times higher than those of practicing companies. A 2014 study from Harvard University, Harvard Business School and the University of Texas concluded that firms forced to pay patent trolls reduce R&D spending, averaging $211 million less than firms having won a lawsuit against a troll. That 2014 study also found that trolls tend to sue firms with fewer attorneys on staff, in effect encouraging firms to invest in legal representation at the expense of technology development. The 2014 study reported that trolls tend to opportunistically sue firms with more available cash, even if the firm's available cash was not earned in the technology that is the subject of the patent lawsuit, and targeting the firms long before a product begins turning a profit, thus disincentivizing investment in new technologies. Emphasis became progressively focused on patents covering software rather than chemical or mechanical inventions. Given the difficulty in defining the scope of software patent claims in comparison to the more easily defined specific compounds in chemical patents, A Gauss study concluded that the proportion of patent lawsuits initiated by trolls hadn't changed significantly from 2007 through 2011. The Gauss speculating that the raw numerical increase in both troll and non-troll instituted lawsuits may be due to the inherently imprecise language, and a lack of common, standardized, scientific vocabulary in constantly evolving emerging technologies such as software. Software patents were described as particularly prone to abuse because software is inherently conceptual, with research indicating that a software patent is 4 times as likely as a chemical patent to be involved in litigation, and a software business method patent is 13 times more likely to be litigated. On June 4, 2013, the National Economic Council and Council of Economic Advisers released a report entitled Patent Assertion in U.S. Innovation that found significant harm to the economy from such entities and made recommendations to address them. The report further stated, specific policies should focus on fostering clearer patents with a high standard of novelty and non-obviousness, reducing disparity in the costs of litigation for patent owners and technology users, and increasing the adaptability of the innovation system to challenges posed by new technologies and new business models. Would likely have a similar effect today. A core criticism of patent trolls is that they are in a position to negotiate licensing fees that are grossly out of alignment with their contribution to the alleged infringer's product or service, notwithstanding their non-practicing status or the possible weakness of their patent claims. The risk of paying high prices for after-the-fact licensing of patents they were not aware of, and the costs for extra vigilance for competing patents that might have been issued, in turn increases the costs and risks of manufacturing. On the other hand, the ability to buy, sell and license patents is seen by some as generally productive. The Wall Street Journal argued that by creating a secondary market for patents, these activities make the ownership of patents more liquid, thereby creating incentives to innovate and patent. Patent licensing entities also argue that aggregating patents in the hands of specialized licensing companies facilitates access to technology by more efficiently organizing ownership of patent rights. In an interview conducted in 2011, former U.S. federal judge Paul R. Michel regarded the problem of non-practicing entities, the so-called patent trolls, to be greatly exaggerated, although there are a number of problems with the U.S. patent system, i.e., most NPE infringement suits are frivolous because the defendant plainly does not infringe or the patent is invalid. Patent infringement suits are very slow and expensive, and venue abuses. NPEs may add value to the patents by buying them up when manufacturers decline to do so. Inventors may have benefited from the developing market in patent acquisition. This view was supported in an article in 2014 that suggests that the pejorative term patent trolls works for the benefit of large organizations who infringe patents and resent smaller inventors being represented by someone with the clout to take them on. The argument against the use of the term is that NPEs, in the main, return the majority of a settlement to the original inventor. Similarly, New York Times columnist Jonas Serra wrote that legislation on patent reforms considered by the United States Congress that have allegedly aimed at trolls often instead effectively tilt the playing field even further towards big companies with large lobby budget.